Don't call down that they don't have it in seat.
Hey, Logie, it's Paul up front. Hey, who's running jail down there? Okay, we are ready. We need Codrington, Philemon, Smith, and Powell. Johnson, we're told, is probably gonna go tomorrow. Joplin, I've already told you. We're unsure when Singleton is. Yes. We can do Codrington and then Philemon and then Smith and then Powell. Great, thanks. Bye-bye.
Did you both hear the order? Yep.
Hold on, necessary paperwork at the back.
Thank you.
Yeah.
Good morning.
How are you, Mr. Nelson?
I'm well. How are you today?
I'm well, thank you, sir.
Marie Coddington?
Yes, sir.
People of the State of Michigan versus Marie Coddington. Ann Arbor Michigan State Police Incident M1212172321. Good morning, Ms. Clinton.
Good morning, Assistant Public Defender Melissa Kleeman on behalf of Ms. Codrington, and we have had the chance to go over the complaint in this matter. She stands mute and waives the formal reading of the charges.
Thank you. Ma'am, you do understand the charges and the maximum penalties associated with these charges if you were to be convicted?
Yes, sir.
Okay. As there's a felony charge here, the court does need to advise you certain rights. You have the right to remain silent. You can say the record can and would be used against you at trial. Do you understand that?
Yes, sir.
You also have the right to be represented by an attorney at all stages of these proceedings. This does include before, during, after trial, and at any time you're being questioned by a police officer. If you're unable to afford an attorney, one will be appointed to represent you at public expense. Do you understand that?
Yes, sir.
Court will have you stand mute to the charge and try not to guilty plea on your behalf, and take a petition for the public defender to represent you in this matter. Public defender's office has provided information with the court indicating you reside on West Huron Street in Ann Arbor. Is that correct?
Yes, sir.
Okay, your telephone number ends in 4895.
Yes, sir.
All right, and you have an email address that ends in the number 87@gmail.
Correct.
Okay. The reason the court's collecting telephone and email addresses is the court may contact you in the future either by phone, email, or text. Is it okay to use those contact points for that purpose?
Yes, sir, it is.
Okay, thank you. Based upon the information provided, the court will endorse the petition appointing the public defender to represent you in this matter.
Thank you, sir.
Court's reviewed the prosecutor's bond recommendation form. Ms. Tink, did you have anything you wanted to add to this as far as bonds concerned in this matter? No? Okay. All right, Ms. Kleeman, did you address bond?
Yes, please. We are requesting a personal bond in this matter. Ms. Codrington does currently stay at the Delanis Center. She is employed, however, at PF Chang's, where she has been for the past year. She is supposed to work today, and we'd really like to see her get out so that she can keep her job and get back on her feet. She is currently also wearing an alcohol tether for a case with Judge Simpson. She's working on getting into sobriety court in that matter.
The people are asking for no contact with an Alexandra Bazareth. Does that cause any conflicts with your client as far as her ability to work and live and everything?
Does that cause any issue for you, ma'am?
No, sir. No, ma'am. I'm sorry.
Okay. All right. Okay. Condition of bond: the defendant is not to use or possess alcohol, illegal drugs, or marijuana, not to leave the state of Michigan without permission of the court. Of course, not to violate any criminal laws, and you will need to appear for all of your court dates. Court will impose a no contact order with the Alexandria Bazareth Meaning absolutely no contact, no indirect contact through family or friends, no text message, email, social network posting, or telephone contact, or any contact of any sort. You understand that?
Yes, sir.
Okay. I've got to get one more screen in front of me here just to get your dates, and we'll get you going here in just a second.
Thank you, sir.
I understand you have a court date coming up soon on another matter. Is that correct?
Yes, sir.
What's that date?
It is August 12th.
August 12th? Okay.
Yes, sir.
All right. Is that too close, Paul, to put on this one on that date? So they're both deciding to run simultaneously?
Yes, but the file will go in, so they could address it and then schedule it. That's your call. If you schedule it for the 12th, I'll have to make it happen.
Okay. All right. We'll set the matter for a probable cause conference on August 12th at 9 a.m. If the matter is not resolved, the probable cause conference will proceed to a preliminary examination. That is a hearing at the point in time the prosecutor must present sufficient evidence and or testimony that the probable cause crime was committed, probable cause defendant committed the crime. Should the judge presiding over hearing determine that probable cause does exist, the matter will be bound over, in other words, transferred to circuit court for trial. Do you understand that?
I do, sir. However, my current date on August 12th, I do believe is at 9 a.m. already, sir.
Yes, same court, same everything. So they'll just have both files there.
Okay, okay.
There's no conflict. I'm not sending you two different places.
Okay,
I want to put everything together so everything's dealt with all at once.
okay, I understand. Thank you. Sir.
If there's any room for resolution, that way the court has everything right in front of it for that purpose, or, you know, and so they know everything else is going on all at once.
Okay, thank you.
All right. So the second court date will be that preliminary examination would be on August the 17th, also at 9 a.m. Those hearings will all take place via Zoom. How long have you been in jail now?
Since yesterday.
And where did you get arrested yesterday?
I went to community corrections to see Miss Megan Wild.
I see. Okay. Okay. And this warrant was out there and been authorized on. Okay. All right. Anything else on bond from the people? Okay. And Ms. Kleiman, anything else on bond?
No, Your Honor, thank you.
Okay. Defendant's released on a personal recognizance bond subject to conditions placed on the record. Should you fail to appear for a court date or violate a condition of bond, a warrant would issue for your arrest. You understand that?
Yes, sir.
Okay, you're all set. Stay safe, okay?
Thank you. You as well. Thank you, Ms. Kleiman.
Thank you. You're welcome.
You guys have a great day.
You too. Ms. Tink, I can't hear you. No, it's maybe sometimes if you leave the meeting and come back in, the audio picks up that way. I'm seeing that you're connected, but we're just not hearing you. If you just pop out and pop back in, I'll bring you right back in.
Thanks, Laura.
Are you on the web client or the Unity client?
No. So if your headphones are Bluetooth, sometimes that causes an interference. Sometimes they just don't work with Zoom for some reason. Sir, your name, please?
Philip Philemon.
Philman?
Yes, sir.
Just working a technical issue here, and we'll be with you in just a second, Mr. Philman.
No. No problem, sir.
Ms. Tink, can you? Nope. Go down to your microphone, your audio settings.
Can you hear me now?
There we go.
Okay. No.
All
problem.
right. Okay.
And just so the court's aware, I'm only here for the Smith matter.
Smith, okay. All right. Sounds good. I will, I'll leave you alone until then.
Thank you.
All right. Morning, Mr. Philman.
Good morning, sir. Real quick, I want to tell you, this happened when I had some other situations.
Hang on. I don't want you to talk about what may or may not have happened. Ms. Kleeman, have you discussed what he's about to tell me with him already?
I'm not sure what he was about to tell you, but I would ask you to just stay silent for right now, sir, okay?
Okay.
Mr. Philman, is there anything that you didn't have an opportunity to speak with Ms. Kleeman about that you may want the court to know? I could put the two of you in a breakout room to have that discussion if need be.
No, if I have a chance just to talk after, if she does, she should probably have it all covered. But if she doesn't, if I could say something, maybe.
Okay, we just want to, make sure that you're not saying anything that's detrimental to you as the case moves forward.
Oh, no. Okay.
All right. Appeal of State of Michigan versus Philip Philemon. This is case number 21FB 1581. Good morning, Ms. Kleeman.
Good morning, Assistant Public Defender Melissa Kleeman on behalf of Mr. Philemon, and we have had the chance to go over the complaint in this matter. He stands mute and waives the formal reading of the charges.
Thank you. All right. Mr. Philemon, you understand the charges and the maximum possible penalty if you were to be convicted of these charges?
Yes, Your Honor.
Okay. As these are felony charges, the court does need to advise you certain rights. You do have the right to remain silent. Anything you say on the record can and would be used against you at trial. Do you understand that?
Yes, Your Honor.
You also have the right to be represented by an attorney at all stages of these proceedings, which does include before, during, after trial, and at any time you're being questioned by a police officer. If you're unable to afford an attorney, one will be appointed to represent you at public expense. Do you understand that?
Yes, Your Honor.
Court will stand mute to the charge, enter a not guilty plea on your behalf, and take a petition from the public defender to represent you in this matter. Based upon the information provided by the public defender, you're living on Judd Road in Saline, is that right?
Yes, Your Honor.
Your telephone number ends in the numbers 8304.
Yes, Your Honor.
Okay, and you currently have no email address?
No, sir.
Okay, it could be helpful to you in the future. You may want to just jump on and get a Gmail email address or sign up for something, free and simple, just so you can engage with court hearings and get things emailed to you. It may
I
help you
didn't
out.
know that you guys actually communicate through email.
In a number of cases, their email notices are sent out, and you'll get things in the mail as well, but it's a little bit easier.
I will definitely do that.
Okay. All righty. All right. Based upon the information provided by the public defender, the court will endorse a petition to appoint a public defender to represent you in this matter. Ms. Kleeman, did you want to address bond in this matter?
Yes, please. We are requesting a personal bond in this matter. Mr. Philemon does have stable housing at the address provided to the court. He has lived there with his wife and their 1-year-old child. He does have a great job as a union carpenter, which he's had for the past year. He is the sole financial support for his wife and his child. So it's very important to him that he gets out so that he can keep his job and keep supporting them. He is on probation. However, the offense date in this case took place before he was placed on probation. And since he's been on probation, he has successfully complied with the terms, including outpatient therapy and GPS tether. And he currently drug tests once a week with Wayne County. He represented to me that it would be very difficult for him to post a cash bond, but again, that it is very important for him to get out. He's very eager to keep his job so that he can support his family.
Okay. And when was Mr. Philemon arrested?
What was the date of your arrest, sir?
Yesterday.
And he did state that his car battery had died. So I believe an officer had pulled over to assist him, and then he had the warrant.
Okay, so no
new charges.
No new charges or nothing.
Okay, all right. All right, and are you still doing outpatient treatment?
Yeah, I'm still doing outpatient as, not, the court's not asking me to, but I'm doing it as my, because I want to.
How long you been clean now?
Man, it's been long. I'm proud of almost a year, and it'll be a year in December.
Okay, all right. Okay. John Hart, is that if the court ordered you not have contact with that individual, would that be, have caused you any difficulties with regard to your living situation or work?
I actually blocked him and cut him out of my life a year ago.
Okay, all right. Well, I'm gonna order you continue to do that.
So I will, trust me, my wife will beat me up if she even seen that name in my phone.
All right, the court's gonna order you have no contact with John Hart. It means absolutely no contact, no indirect contact with family or friends, no text message, email, social network posting, telephone contact, or any contact of any sort whatsoever. That condition will be placed in the law enforcement information network, meaning should you come into contact with police, they would have access to that information. Should they witness or suspect a bond violation to have occurred, that would result in your arrest of the bond violation. So if you come into contact with police and he's there, that's gonna be a problem. Okay,
Not gonna happen, not gonna happen.
understood. Okay, all right. These are felony charges, so your next court date will be what's called a probable cause conference. The 19th, August 19th at 9 a.m. via Zoom. The court will mail you a notice with the Zoom information. If you don't receive that, or otherwise don't get it, don't have it by the time that court date comes along, you can always call the court. The clerks can give you information over the telephone as well. If the matter is not resolved at that hearing, it proceeds to what's called a preliminary examination. That is a hearing at which point in time the prosecutor must present sufficient evidence and or testimony that there's probable cause the crime was committed and probable cause you did commit that crime. Should the judge presiding over that hearing determine that probable cause does exist, the matter would be bound over, in other words, transferred to circuit court for a trial. You understand that?
I do.
That court date will take place on August the 24th, also at 9 a.m. via Zoom. Okay. All right. Defendants released on a personal recognizance bond, subject to conditions placed on the record. Should you fail to appear for either the court dates or violate a condition of bond, a warrant would issue for your arrest. Do you understand that?
Yes, Your Honor.
Okay. Ms. Clayman, did you have anything else on that?
No, Your Honor, thank you.
Okay. All right. So you're all set. Stay safe. Okay. All
Thank you, sir. I appreciate your time.
right. Thank you.
I can leave?
Yeah. Let them know you're all set.
Okay.
Morning, sir. Your name?
My name is Jerome Powell.
Actually, we need to see you a bit later. Could you let the officers know we need to see Mr. Smith next? You corrections officers know that.
Okay.
We'll see you after him.
Okay. Mr. Smith, you said?
Yep. Thank you. I'll have a total on-base fail here.
Huh. You're in the Unity class.
Yep. It
Well,
was there a minute ago. But now it won't, it's not responding. So when we're done, I'll reboot and see if I can get it to go or something.
This, that's powerful.
Ms. Kleeman, while we're waiting, were you able to review the complaint with Mr. Smith?
Yes, I was.
Okay. Morning, sir. Your name?
Lewis Junior Smith.
Thank you, Mr. Smith. Real Estate of Michigan versus Lewis Smith. So case number 21F55097. Morning, Ms. Kleeman.
Morning.
Good morning,
Assistant
Jennifer.
Public. Oh, I'm sorry. Go ahead.
Go ahead, Ms.
Good
Tate.
morning,
I'm sorry.
Jennifer Tink for the people.
Thank you.
I'm Assistant Public Defender Melissa Kleeman on behalf of Mr. Smith, and we have had the chance to go over the complaints in this matter. He stands mute and waives the formal reading of the charges.
Thank you. Mr. Smith, you understand the charges and the possible maximum penalties of each of these counts if should you be convicted of these charges?
Uh-huh.
Okay. All right. As these are felony counts, the court doesn't need to advise you certain rights. You do have the right to remain silent. Anything you say on the record can and would be used against you at trial. Do you understand that?
Yes.
You also have the right to be represented by an attorney at all stages of the proceedings, including before, during, after trial, and at any time you're being questioned by a police officer. If you are unable to afford an attorney, one will be appointed to represent you at public expense. Do you understand that?
Yes.
Court, I stand mute to the charges, enter a not guilty plea as to each count, and review the petition for the public defender to represent you in this matter. The court has reviewed this petition. Indicates your permanent mailing address is on Andrea in Ypsilanti. Is that correct?
Yes.
And the best telephone number to reach you is 303 ends in 8038. Is that right?
Yes.
Okay. All right. Based upon the information provided, the court will endorse the petition appointing the public defender to represent you in this matter. Do people want to address bond?
Yes, Your Honor, we would be asking for a remand in this case. This defendant is on parole and has violated his parole. He was arraigned yesterday on a drug charge out of Ypsilanti. He has an extensive criminal history. The charges in this case are very serious: kidnapping and criminal sexual conduct with a stranger. In addition, there is another warrant that is likely to be signed next week against Mr. Smith with very similar circumstances with the criminal sexual conduct charge. We are concerned about the safety of the community as well as him being a flight risk.
Okay. As to a pending charge or possible additional charge, court can't take that into consideration at this point in time because it's not before the court, but the court's heard the balance of your argument. Ms. Kleeman, did you want to respond?
Yes, and we are asking the court to set a reasonable cash bond. We do realize that these are very serious charges. If released, Mr. Smith does have stable housing at the address provided to the court. That is his sister's home, and he would be able to stay with her. He has, however, been incarcerated for the past 10 months while awaiting trial in another matter. That trial has now taken place, and he was found not guilty on all counts. He is currently unemployed because of the incarceration, but previously worked as a janitor, and he is hopeful to find a similar job if released. He does have that parole hold, however, he has not spoken with his parole agent yet, so he's not sure how they will be proceeding. And he did state that a no contact order would not be an issue for him. He represented to me that he is unfamiliar with who the complaining witness is.
What charge is he on parole for?
What are you currently on parole for, sir?
Possession charge.
All right. So the people are requesting the court deny bond in this matter. The charge does qualify for denial of bond. Ms. Tink, do you have anything you wanted to add to your argument regarding the
No, Your Honor. Thank you.
requirements for the court to make that finding?
No, Your Honor.
Ms. Kleeman, do you have any response to the request for no bond in addition to anything you've indicated here?
Nothing additional, thank you.
Okay. All right. All right. Michigan statute and constitution allow the court to consider the denial of bond in the limited scope of cases. Included in those cases would be the charges presented here before the court would be a court case for which no bond would be permitted. If the court makes determinations, court doesn't need to make findings to deny bond. Those findings have to include either there's proof of the defendant's guilt is evident or the presumption of guilt is great, but that does not mandate a denial of bond. The court can utilize that to make the determination as to whether or not bond should be denied in a matter. Court having taken testimony previously to the hearing from the officer supervising this matter went into great detail with regard to the allegations and with regard to the likelihood of conviction in this matter. The court does find that there is great proof of defendant's guilt is evident. Therefore, the court can invoke the constitutional provision to deny bond. And for that reason, the court will deny bond in this matter. The defendant is remanded to custody until such time as his next court hearing can take place. The probable cause conference will be on August the 19th. Should the matter not resolve at that hearing, it proceeds to a preliminary examination. And as a hearing at which point in time, the prosecutor must present sufficient evidence and or testimony. There's probable cause crime is committed, probable cause the defendant did commit that crime. Should the judge presiding over the hearing determine that probable cause does exist, the matter will be bound over and was transferred to circuit court. That hearing will take place on August the 24th. Do you understand that, sir?
Yes.
Okay. All right. You're all set. Be safe. Okay.
All right.
Thank you.
Thank you.
Hi,
Hello.
who would you like next?
I believe Paul is our next and last person.
Okay.
I can take my mask off.
Yeah, that's fine.
Jerome Powell?
Yes.
All right. We're waiting for the prosecuting attorney to enter into the Zoom environment. Should be just a moment. As soon as the attorney's here, we get started, okay?
Okay.
Except for.
Morning, Ms. Reiser. You hear us okay?
Good morning, Your Honor. Yes, I can.
Excellent. Thank you. All right. People of the State of Michigan versus Jerome Powell, case number 21F00870.
Patricia Reiser on behalf of the people.
Thank you.
Assistant Public Defender Melissa Kleeman on behalf of Mr. Powell, and we have had the chance to go over the complaint in this matter. He stands mute and waives the formal reading of the charges.
Thank you. Mr. Powell, you understand these charges and the possible maximum penalties should you be convicted of these charges?
I believe so.
Okay. Would you like me to read them to you?
Yes, please.
Certainly. The allegation is that between the dates of June 30th and July 15th of 2021, in the city of Ypsilanti County, Washington State of Michigan, at or near 9 North Summit Street, you did make an assault upon Matthew Lambert with the intent to do great bodily harm less than the crime of murder by strangulation or suffocation. That is a felony carrying a maximum penalty if convicted of a term of up to 10 years in prison, a $5,000 fine, or both. Do you understand that?
Yes.
And count two, same as the first, is that you did make an assault upon Matthew Lambert with the intent to do great bodily harm less than the crime of murder or by strangulation or suffocation. Again, a felony carrying a maximum term of up to 10 years in prison, a $5,000 fine, or both. Do you understand that?
I understand.
As these are felony counts, the court needs to advise you of certain rights. You have the right to remain silent. He's saying the record can and would be used against you at trial. Do you understand that?
Yes.
You also have the right to be represented by an attorney at all stages of these proceedings, which does include before, during, after trial, and at any time you're being questioned by a police officer. If you're unable to afford an attorney, one will be appointed to represent you at public expense. Do you understand that?
Yes.
Or you stand mute to the charge, enter a not guilty plea on your behalf, and take a petition for the public defender to represent you in this matter. Public defenders provided the court with information collected from you earlier today, indicating your telephone number ends in 4055. Is that correct?
Yes.
Okay. And you currently do not have an email address. Is that correct?
I do, but I don't have access to my computer or my phone as of right now.
Okay. Would that be something you would have access to in the near future?
I mean, if I'm released, I would.
Okay. Do you know your email address?
Yes.
Or what is that?
It's Jerome.Powell1976@gmail.com.
Okay. All right. The reason the court collects email and telephone numbers is in the future, the court might text or email you with information about your case. Is it okay to use those contact points for that purpose? Okay. Obviously, the default will be mail. We have an obligation to mail everything, but in addition to that, you may get emails or texts. Okay. Based upon the information provided by the public defender, the court will endorse the petition appointing the public defender to represent you. People want to address bond?
Yes, Your Honor. As I indicated on the bond form, we are requesting a surety bond in amount of $50,000, as well as confinement to a residence with a tether. I'm concerned about the victim in this case, as well as the general public. As the court knows, the allegations are 2 counts of assault with intent to do great bodily harm. And in both cases, the victim was strangled. The second occasion, he did pass out. He was threatened by the defendant that if he got the police involved, that he would be killed. The defendant also threatened to kill him if he tried to move out. They are roommates. So of course, we're asking for the no go-to order to the location. And although there is no intimate relationship here, there are what I would consider some DV dynamics, specifically the threat that if he tried to move out, he being the victim, that the defendant would kill him. The victim did share what was going on with his coworkers and with his parents, and they were all very concerned for his safety, encouraging him to contact the police, but he advised them he had been threatened. So we are asking for that high surety bond as well as all standard bond conditions, including the no contact order and the no go-to order, and confinement to a residence other than the Summit address with the tether.
Thank you. Ms. Kleeman, did you want to respond?
Yes, we are asking the court to set a low cash bond in this matter. Mr. Powell does have a parole hold, and he believes after speaking with his agent that that is going to continue to hold him in jail. He does live locally. However, the complaining witness does live at his legal address. So he does understand that if released, he would need to find another place to stay. He'd need to update the court with that address once he has it. He does also work at U-Haul and worked at Costco before that. So he has been consistently employed, and he did represent to me that he would not be able to afford much of a cash bond. So again, we are asking the court to consider a low cash bond, low enough that he can post if and when his MDOC hold is cleared.
And what is he on parole for right now?
What are you on parole for currently, sir?
On parole for, it's been so long. I think unlawful imprisonment. It was like
Okay.
over 10 years ago.
Okay. All right. Aside from your living situation, do you have any reason to have contact with Mr. Lambert? Do the two of you work together or have any other places you need to be in common aside from the living arrangement?
No. It's really hard listening to this. Is there any way that I could say something about this?
I would recommend that you don't right now, sir. I don't want you to say anything that might incriminate you.
It's just
Did you want to speak with your attorney in private briefly after hearing the people's argument?
Yes.
Okay. We'll set up a breakout room. Two of you can speak briefly about where we're at.
Thank you.
So you just need to let the corrections officers know that you're going to be put into a breakout room. Okay.
Okay. Right now?
Yeah, just tell them. Yep. Tell them you need a breakout room. They'll come in and take care of that.
Ms. Cleveland, where did you get the information about the parole hold? I didn't see.
It was in X jail, and then my client represented that he had spoken with the agents.
Thank you. Your Honor, I'm going to run back to juvenile court. I'll be right back.
Okay. I wish I could close breakout rooms faster than 60 seconds. Ms. Clayman, are you there?
I am, yes.
Okay. Closing the breakout room just takes time. No, we just need the prosecuting attorney back again, and we'll start up again in just a second. Just received notice that they're finishing up, so should just be a moment. Apologize for the delay. Recall appeal of State of Michigan versus Jerome Powell Jr. 21F0870. Ms. Kleeman, you had an opportunity to speak with your client. Is there anything else you wanted to add?
I did. He just wanted to emphasize for the court that he does maintain his innocence in this. He is adamant that nothing happened with the complaining witness. He was surprised in particular about the allegation that he had threatened him not to move out of the house. And he stated that was because he's actually tried to get him evicted in the past. And he does believe that his landlord would testify to that. He just wanted the court to be aware of that. But apart from that, that's the only additional information I have.
Thank you. Ms. Reiser, anything else on bond?
No, thank you, Your Honor.
Okay. All right. Set the matter for a probable cause conference August 19th. Matters not resolved, that hearing will proceed to a preliminary examination. That is a hearing at which point in time the prosecutor must present sufficient evidence and or testimony. Probable cause crime is committed, probable cause defendant committed crime. Should the judge preside on the hearing determine that probable cause does exist, the matter will be bound over, in other words, transferred to circuit court for trial. Do you understand that, Mr. Powell?
Yes.
Okay. All right. As to bond, court will set the following bond conditions. The defendant is not to have contact with Matthew Lambert. There's absolutely no contact, no indirect contact through family or friends, no text message, email, social network posting, telephone contact, or any contact of any sort whatsoever. This condition will be applicable whether you're in jail or not in jail. Do you understand that?
Yes.
Now to the address of 9 North Summit and to maintain a 1 mile radius away from 9 North Summit. Court will order GPS tether to monitor the compliance with not to be within 1 mile of 9 North Summit. Do you understand that?
Yes, I have a question though, in regards to if I was released, and I had to get my belongings from 9 North Summit.
I got you. Yeah. So the one exception to the not to return to that address is you may do so, but you have to have a civil standby, meaning, you have to have the tether first. Then you go to the sheriff's department, tell them you have a or to the Ypsilanti City Police. You have to go to the city police department, tell them you have a civil standby order. They need to coordinate with you and the tether monitoring folks that you're going back there at that point in time for the purpose of collecting personal belongings. Okay. So that'll be the exception. They'll see you go in there, but they'll know you're going there to collect personal belongings with a police officer. And that'll take care of that part of it. Okay.
Okay.
All right. Additional conditions: not to violate any criminal laws, not to use or possess alcohol, legal drugs, or marijuana, not to leave the state of Michigan without permission of the court. Do you have any questions with regard to these conditions?
No.
These conditions will be placed in the law enforcement information network, meaning should you come into contact with the police, they would have access to that information. Should they witness or suspect a bond violation to have occurred, you wouldn't be arrested for that bond violation. You understand that?
Yes.
Ms. Kleeman, anything else on bond or other conditions?
No, Your Honor, thank you.
Anything from people?
Your Honor, did you order no weapons, firearms?
Thank you. In addition, the defendant is not to use, not to possess or purchase a firearm, ammunition, or other dangerous weapon. Do you own any firearms, sir?
No, but I did, just so you, I'm sure you already know, I'm on parole.
Right. So you're not eligible. Yeah.
Right, and, but they did, take a knife, off of like my altar.
Okay.
in my house. So my parole officer, he already told me that I should have contacted him and asked him if I could have that. But my question is, what about like cooking knives, you know, like in the
Look,
house?
you know, be sensible about it. I mean, you know, possession or purchase of a firearm, ammunition, or other dangerous weapon, you know, comes down to the use of it. I mean, if you have a steak knife and you're cutting a steak with it, you're not utilizing it as a dangerous weapon, right?
Yeah, that's what I thought.
If you pick it up and branch it in somebody's face, now you violated your bond because you utilized it as a dangerous weapon. Okay.
Yeah, I mean, that's what I thought, but they took my weapons, what they call weapons, out of my house, and they weren't used for anything.
Yeah. Well, I'm addressing my bond condition, the court's bond condition. I'm not addressing your parole condition. You talk to your parole officer about that. And if he wants you to use butter knives from now on, that's up to you, between you and your parole officer. Okay. I'm just telling you how the court's going to interpret dangerous weapons.
Okay.
Okay.
Yeah.
All right. Okay. All right. The tether condition is to be had prior to release from jail. So you need to make arrangements with community corrections to have your tether in place prior to release from the jail. Court will, in addition to that, be given the parole hold and other factors, set a cash bond to ensure public safety and appearance of future court dates. That bond be set in the amount of $7,500 cash or corporate surety, subject to conditions placed on the record. All right, so you're all set. Stay safe. Okay.
Okay. You too.
Thank you, Your Honor.
Sorry, what was his PCC date?
That'll be on the 24th. So the 19th is PCC. I'm sorry, 24th. Or is it
Okay.
exam?
Okay, thank you.
So I have a question. When's the next time I will see you?
Ms. Kleeman, you mean?
Yes.
So you're going to be assigned to someone else within my office next, so they will be in contact with you as soon as they have the discovery. So it'll be sometime before that August 19th date for sure.
Okay. All right.
1 mile radius, north side, 9 North Summit prior to release. Okay, all right, so you're all set. Okay, have a good day. Stay safe.
All right, you too.
Thank you.
Thank you.
Thank you.
All right. Ms. Kleeman, I understand we have charging documents on what's last one? Singletary, so I just need to go off the record here, get that sworn to, and we'll come back to that.
Okay, sounds good.
Ms. Reiser, are you going to appear on this one?
I can hang around. I don't know if you'll need me or if you have any questions.
Okay. And Ms. Kleeman, if you could email Paul the PD form.